Good morning, everyone. Thank you for joining us today in person and online for our May Aitken Partners Breakfast Seminar on estate planning essentials, tips to avoid or navigate wills disputes. My name's Alister Bayston. I'm head of commercial in the Aitkens team. Today's discussion will focus on the practical realities of estate planning, including common sense issues that can give rise to disputes, the steps that can be taken to minimise through risk-effective planning, and how disputes can be navigated. We'll also touch on the role that advisors, financial advisors, can play in this increasingly complex financial world of family structures and generational wealth transfer. This is an area I'm somewhat evangelical about, and I'm often giving either friends or colleagues a bit of a push about the importance of estate planning and having a valid plan. Now, I know this is a very private question, so I'm not going to ask any of you who does not have a will, but put your hand up if you think you've actually got a current binding and an appropriate will. Okay. And now, if you put your hands down, we've made a note of one of the ones that didn't put their hand. They would be circulating tossed ingredients. This is an area that continues to evolve, particularly with changing economic conditions and recent federal budget announcements. We've seen extraordinary generational wealth transfer, and that's prompted some very careful and thoughtful consideration of what the vision from the testator is for the family wealth. And there's those that have not planned adequately or haven't contemplated the unexpected. So feel free to ask questions throughout the session. And webinar audience, there's a Q&A function which you can type a question into, and they'll be relayed to us and we'll answer it as we can. I'd like to introduce the panel. We have first Susan Bonnici. Susan's a principal estate planning lawyer and head of the Wills and Estates team. She's practiced extensively in areas and trust since her admission. With extensive experience across estate planning, estate administration and estate disputes, Susan is known for providing tailored, practical advice that reflects each client's unique personal circumstances and has an additional specialisation in disability trusts. Carl Wilson, who is at the end of the table there, he's also in our Wills and Estates team in Aitken Partners. He advises across a broad range of estate disputes. So I think about Susan as being the GP that protects and manages and plans. And we've got Carl, who's the paramedic, or the thing's been serious, that a surgeon. So Carl specialises, does a lot of work in applications involving executors and trustees, and he's known for providing clear, practical and strategic advice. Alex, a close ally of Aitken Partners, but not one of ours. He's a member of McQueen Group, a financial services organisation, which he joined in 2015 after spending nearly a decade in the financial services group. Known for strong client relationships and a practical approach, Alex works closely with clients to develop tailored advice strategies and with their long-term financial goals and aspirations. His methodical, client-focused style helps clients navigate both immediate financial decisions and broader wealth planning considerations. Please welcome our panelists. We hear a lot in the media about anecdote about people challenging wills or making claims to receive a greater share of the estate. And anecdotally, I see that amongst my peers, and it is tough on families and probably at the wrong time of things. As a senior lawyer, Carl, working in estate litigation, can you explain for us when a will can be challenged and who can challenge an estate?
Thanks, Al. I think there's certainly a perception created primarily, often by media, some sensationalist media coverage that wills can be challenged and that there's more or less a cottage industry that's grown up in challenging wills. And that's really an example of that that I'd just like to take you guys to. Is an article from the Australian Financial Review, dated the 7th of February 2025, which I'll read very briefly from. In 2023, Anna Stamoutsas wrote a will bequeathing her $1 million estate to her daughter Labrini, wholly excluding a second daughter, Aristia. Surely the existence of a valid will containing Anna's express wishes should be enough to guarantee faithful execution of her last wishes. Not so. Aristia challenged the will in the county court and came away with $475,000, or about 41.38% of the estate. Anna and Aristia had a strained relationship stemming from the deceased's quote-unquote difficult temperament and cultural issues. Nevertheless, the judge found the willmaker had a moral duty to provide for Aristia, who was a single mother with limited finances and some health problems. I say that case particularly close to my heart because I acted for Aristia in that case. And that's one of the largest judgments that the county court has ever made in a family provision claim. But what I think of this article underemphasizes is the special circumstances, the unique circumstances of a claim like that. The article says that, quote unquote, Aristia was a single mother with limited finances and some health problems. Aristia, in fact, had basically never worked. She was in her late 40s. She had multiple health conditions, including complex PTSD, ADHD. She had a young son under the age of 10. The father of her son was not paying any child support. On top of everything, on the morning of the trial, she received an eviction notice on the property that she was renting. So this was a very special culmination of factors that made that sort of claim possible. But what I would emphasize is that, generally speaking, that's the exception rather than the rule. Because since 2015 in Victoria, the categories of claimants who are able to even make these claims has been cut down very substantially. Effectively, for practical purposes, it's children, domestic partners, wives, stepchildren. There are some other exceptions, but they're very rare in practice. And in all of those claims, there's a primary threshold test essentially to show some financial need. And when I say financial need, you don't need to be on the level of the Aristia Stamoutsas or living in a car. What we commonly see in claims like this is people who might be in their late 50s, they've been through a divorce, they have a substantial mortgage, or they're at the end of their working life with no superannuation. That's the sort of the financial need that one often sees in these cases. And the way that those cases therefore play out in practice is that if a claim is made, a settlement or court order is generally tailored around that financial need that the claimant has shown. So if the claimant has got a mortgage of, say, $150,000, or needs a top up on their super of, say, $200,000, court might order, or would there be a settlement of the case where there's a limited carve out from the estate, that amount, placed perhaps a little bit on top for costs. But I'd certainly not, it's not my perception at the moment that there's any sort of free for all in these cases, particularly where there's been proper estate planning and thought given to how to structure the will. One of my final observations on that point is that increasingly what I'm seeing in these cases is that the defence of family provision claims is starting to be concentrated in the hands of firms like Aitken Partners, but there are others that have a particular expertise in these sorts of claims. But often you see that the will might have been drawn by a suburban solicitor, and that will cuts out a child, for example. Then you see a grant of probate obtained by that local solicitor, but within 1 or 2 months, the executor essentially goes to a city lawyer, stronger city lawyer, and defends the claim with a lawyer with the particular expertise and resources in this sort of area. But it's a challenging time for these sorts of claims. The other type of claim that I do want to just touch on, because we're going to talk about it a little bit later, is a capacity type claim. Essentially in those sorts of claims, the will is challenged not on the basis that a particular beneficiary doesn't get enough from it, but because the person who made the will didn't have legal capacity at the time when the will was made. But they might have been suffering from dementia. They might have been suffering from Alzheimer's disease. They might have been suffering from schizophrenia, any other sort of mental disorder of that nature. But my observation in practice from doing thousands of these cases is those sorts of claims are quite rare. There ordinarily one finds that people make wills with a solicitor. It's ordinarily the practice that solicitor takes careful file notes and obtains some sort of medical evidence to satisfy them, the person in what they're with. That's really, I would say, that the battleground in estate litigation is primarily on the family provision claim platform rather than on the capacity area.
Yeah, I'm also part of a video that media hype about the prevalence of challenges to Dickens fans will remember the case of John Dice and John Dice, where 2 families litigated until there's nothing left in the estate. So it was a mutually assured destruction, perhaps not the original intention. But another myth I wouldn't mind helping bust with me is I understood that an applicant for challenging the will could get their costs paid out of the estate and thereby remove the cost burden from doing this, which suggests to me that why not have a crack? But I'm pretty sure it's not that simple.
The cost question is a really good one. Now, there was, for many years, there was even a provision in the Act that essentially provided for costs to come out of an estate for a successful applicant. And on the back of that legislative provision, there sort of grew up a practice that there was an expectation as part of any settlement of any claim that a claimant would get their costs out of the estate. Now, rightly or wrongly, my experience is that sort of practice continues. And practice means a lot in this jurisdiction, because the law is one thing, but what's happening on the ground day-to-day in mediations can sometimes be something completely different. So what you would normally expect to find in a mediation of your typical garden variety family provision claim is that you might have costs of each side somewhere in the range of 35 to 40,000, which sounds a lot, but probably there's other jurisdictions.
It's not enough.
But there's other jurisdictions, family law, commercial law, which have much bigger numbers than those. And so that's the sort of cost you'd expect. Now, there's generally, as part of any deal, everyone's costs would be taken off the top, and then the rest of the estate would be divided either on a percentage basis or lump sum. But I think, from an estate planning perspective, that practice is relevant, because if you're thinking of cutting out, or someone is thinking of cutting out a beneficiary, what you can take as read is that there will be a claim against the estate, subject to that financial need threshold that I was talking about. But B, those costs will come out of the estate. And if there's 2 sets of lawyers, we're talking 75 to 80,000 there's 3 sets of lawyers, could be 100,000. Sometimes you see that these disputes with 4 sets of lawyers. So you can just do the arithmetic. Just keeps on growing. That's something I always think when I'm speaking to clients who are minded to cut people out. I would have thought that's something to really consider, because effectively you're a huge chunk of the estate. $1 million estate, we might have 10% of it going up in smoke and legal costs. That's fine.
Yeah, thanks, Carl. And look, on the approach to using an appropriate lawyer for what a will, often surprised where people sometimes cut corners on costs. If you talk about everything you've generated in your line of work and what you've generated through your ancestors, and you get a news agent will, doesn't resonate. Here's the big. Susan, broadly speaking, are you seeing a growth in these sort of claims? Thoughts, and what do you think is underpinning that?
We are sort of seeing a growth in the amount of family provision claims that are being brought. And I think the background to that is the shift in demographics and the environment, economic factors that are occurring just in the community at the moment. A couple of stats that I've pulled out just to sort of illustrate the huge changes that are happening in estate administration, estate disputes, probate, and succession planning. There was a 2024 report by JB Weir, which estimates that in the next 2 decades, there'll be a $5.4 trillion transfer of intergenerational wealth. So that's the amount of funds that are going to be transferred from one generation to the next over the next 20 years, $5.4 trillion. Another study by the Grattan Institute revealed that the average net wealth of households headed by someone between 65 and 74 years is now $1.3 million. Back in 1994, that was only $530,000. So there's been a huge growth in the value of estates as well, largely due to property prices and the expansion of superannuation. The ageing population has also meant that now more people are dying, and that rate will continue to increase. So in 2024, there were around 185,000 deaths in Australia. And in that, the ABS has forecast that by 2030, which is only 4 years away, somewhat shockingly, that number of deaths per year will be over 200,000. So death rates are increasing and the value of estates are clearly rising significantly. There's also a huge disparity now between the amount of wealth in different generations. So you can see, baby boomers now are 3 times more likely to own their own home than millennials. And 80% of Australians over 65 years own their own home in 2021. So the amount of wealth held and accumulated by the older generations is clearly a lot higher than 35 to 45-year-old brackets where household debt has doubled recently. So there's a huge disparity in wealth, growing number of deaths. Assets are being held in more complicated ways as well. So different structures and companies, digital assets, cryptocurrency. There's a whole range of factors, which means that people need really good advice when it comes to estate planning. And if people are being excluded from wills, they have more incentive, I guess, to try to do something to bring a successful challenge.
It isn't it? But from a wills and estates perspective, that's a business plan that lies itself. How do those stats resonate with what you're seeing in practice on the dispute side of the equation? And we've got examples that you might share with us about what went wrong, what remedy was sought, and maybe even what could have been done differently.
Certainly that's the case. A number of these claims is inspired ever, and I think it's only going to grow. I think the factor that Susan mentioned that I think is the most critical one is the fact that house prices being so high that there's an element of desperation that creeps in to people when they see that mum or dad might not have long to live. I'll give you an example about how this plays out with capacity disputes. Often it's very common in our space to have mum or dad living alone with an adult daughter or son who may never have left the house or may have left the house and come back to the house. And perhaps things in their life have not quite gone to plan, and they're living under the same roof with mum or dad. Sometimes that's a relationship that works for both parties because the elderly mum or dad gets companionship and support, someone to take them to their medical appointments, and the son or daughter gets a roof over their head. But what often happens is the older that person gets, let's say they get into their late 80s, they might start getting the early signs of dementia. They may become increasingly frail. Then there's some sort of incident. For example, they have a fall that requires a hospitalization. And then it quickly dawns on the child living in the house that they are particularly vulnerable because dad might not have long to live or mum might not have long to live. And they die and the will leaves the estate equally to the other brothers and sisters. There's a high probability they're going to be out on the street. And if house prices being what they are, realistically, they're never going to be able to get into the housing market. But what happens? Often one sees that after such a medical incident, sometimes within days, sometimes within weeks, a will appears, which gifts the residence to the son or daughter living in the house. You see different versions of it. Sometimes mum or dad is sort of marched off to the local solicitor where they meet that solicitor for the first time. It might not be their family solicitor. And a will is drawn. Sometimes you see the notorious post office will kit. We had an interesting claim here at Aitken's earlier in the year where it's sort of quite a back scenario where dad was in his late 80s, early stages of dementia, had a big fall, spent time in Box Hill Hospital. The adult son, who in fact never left the home, so within 10 days of dad leaving Box Hill Hospital, that being a homemade will kit will made that was drawn by the deceased. It wasn't a fraud. It was drawn by the deceased in his own handwriting. It was obviously had the hands of the adult son involved at all stages because he was driven to the local chemist warehouse at the Pines Shopping Centre in Doncaster. And the will was that witness there. The other witness to the will was the adult son's girlfriend, who also lived in the house. There'd been a history of past domestic violence in the property. We, in fact, issued a subpoena to the Victoria Police and obtained a whole ream of material going back 15 years of our police attendances at the house. So we built a case where, based on capacity, a lack of capacity and undue influence and coercion. And we were able, the case was referred to the court-ordered mediation, which all of these cases are. And we settled it. And we got a strong settlement based on the fact that we had this homemade will in the police attendance. There's a whole sort of series of factual sort of matters that sort of cast doubt on the making of the will. But that's a sort of example in practice of what you see. And I think that just sort of consistent with what Susan is saying about that, the issue of property prices is the driver of a lot of these disputes.
It is heartbreaking, isn't it, to see the behaviour of some people at a crucial stage of life when things could be quite different. So characterise Susan as you, the GB, the prevention. So if we think about situations like that where there's been poorly well, I think it could be different. There's not just poorly handled in that case. You've got mischief involved. What sort of strategies can people use to try to reduce the risk of a challenge to a will that the testator's wishes flow through as intended?
Yeah, that's a really good analogy, Al. I'm like the GP, so I'm there to protect the will, explain the risks, make sure that everything is done properly so that there's no surgery or anything required later on. So there's a few different risks and challenges that can arise that Carl has explained. The first is really around testamentary capacity. So that's one of the first tests that I'll go through when I'm meeting a client. Do they understand the nature of their assets? Are they able to provide clear instructions? Do they understand their moral obligations to provide for people? Are there any illnesses or diagnoses that might impact their cognition and their ability to understand the documents that we're preparing and signing? If I'm not sure about that, or if there's any sort of doubt in my mind, I'll also request medical evidence that can then be used if the will is challenged on those grounds. So that's how I sort of deal with the testamentary capacity issue at the planning stage. There's also the undue influence risk that we see quite a bit, where there are sometimes well-meaning family members involved, sometimes not so well-meaning family members involved. It is quite common that adult children will bring their elderly parents to a meeting because they are the ones sort of looking after them and driving them around and like being there to support them through their aging years. But there is sort of a limit there in how much that person can be involved in that planning stage. And I've got to make sure that they're not exerting any influence or control over that person's decision-making when they're making their will. That means taking instructions from the client by themselves, making sure there's no one else in the room when they're giving instructions or signing the will, trying to get a glimpse into their home lives to make sure that they're not being coerced or abused or influenced in any way when making these types of decisions. A big thing as well that I see quite commonly in my practice is clients coming in and saying just outright, I know what the risks are. I don't care. I hate this son of mine. I'm not naming him in my will in any way. I haven't spoken to him in 30 years. I don't care. I don't care what the costs are. I'll be dead, whatever. I just don't want this person to get anything from my estate. There are some strategies that we can talk through there to reduce the risk of a claim or to mitigate that risk. The big thing to understand when it comes to everybody's estate planning, so this is about advice for everybody in the room, whether there's a risk of a challenge or not, your estate the only assets that will form part of your estate are those that you own in your sole personal name. Anything that you own jointly with somebody else doesn't form part of your estate. If the other owner survives you, it automatically goes to them. Anything that you own outside that's not in your personal name, so if it's held in a family trust, if it's held in super, if it's held in a company, they're not your personally held assets. So sometimes a strategy that clients will choose to use is to move assets out of their personal name into either another entity or to own it jointly with another party. And there might be stamp duty or tax consequences for doing that, change of ownership. But that will effectively reduce the size of the estate, which might make it less appealing for somebody to bring a challenge because they can only claim upon whatever's in that asset pool. There's a few other strategies that we can use. So where I do get a client who's just adamant, I hate my son, I don't want him named in the will, one thing that I will ask them to do is to provide a separate letter where they might explain in that letter the reasons why they've made that decision. It's not part of the will, it's just something that can be stored with the will. And that letter can then be used as evidence if there is a mediation or there is a trial that challenges the estate. Obviously, the will maker is not going to be around at that point in time to speak for themselves. So having a separate letter where they can explain the nature of the estrangement or whatever the factors are or why that person has been excluded. Sometimes it might be the person says, I've given this child of mine $50,000 every 5 years to bail him out of all of his failed business ventures. He's got enough from me. I'm not going to support him anymore from my estate. And that can be quite a strong factor in defending a claim. So putting all of that in writing as well, whether it's just in my file notes or if it's a letter from the will maker, can be quite an effective strategy. There's also a few different things that we do with blended families, which is another huge reason for this catalyst of claims being brought against estates, where there's a rise in blended families now, and that creates all sorts of complications from estate planning, estate administration, and estate disputes. Often one thing that I will recommend with blended families is for each member of the couple to have their own assets that they can leave to their respective children, so that it's not all going to the surviving spouse, who can then change their will and leave everything to their own biological children. That sometimes might involve severing a joint tenancy on a property, putting life interest or rights to reside into the will, so that each party will have their own assets that they can pass down to their kids. Mutual will agreements can also work in that context as well, where they've got a couple who both have children from previous marriages, and they both of them have the intention to, if they both pass away, to leave everything to all of the children in equal shares. But you want to make sure that the surviving spouse isn't going to change their will. They can effectively sign a contract that says, if you die first, I promise that I'm not going to change my will. I will leave it so that everything goes to the four or five children in equal shares. So there's some of the things that I do to try to make sure.
Would I be able to say something?
Yeah.
Susan's very interestingly touched on the mutual will contract point in second marriages. And I thought, just from a litigation lawyer's perspective, I just like to relay just that it's an observation that I've seen from practice, which and anyone who practices in his space might have one or two these cases on the books at any given time. Inevitably, what happens with blended families, say dad remarries, he's got two kids, then his wife's got two kids. They might have a great marriage and a great second marriage. It might be even better than the first marriage. Everyone's very friendly. They go off to a solicitor and make what's called mirror wills, where each of them agree that whoever goes first, they'll lead it to the other, and then equally to the four kids, like the two step-ins and the two biological kids. And that all sounds fantastic, and I've seen any number of these mirror wills. But inevitably, what happens is that the dad goes first, just through biology. Men seem to die first, and then the surviving stepmom or mum goes out to a solicitor. Sometimes within months of the person dying, changes the will to leave everything to her own kids and cut out the stepkids. And sometimes you'll even go back to the very solicitor who made the will. I don't know what it is about human nature, but it's an incredibly powerful instinct to want to do that, to leave everything to your own rights. And I've got a case at the moment where our client's dad remarried. He passed away. He had a will where he left most of his estate to his second wife, but a little bit to the kids. Second wife made a family provision claim, saying she wanted the whole estate, but basically cut out all of the kids. That case settled many years ago, 2006. 20 years have passed. She's now died. Having taken her stepkids' inheritance effectively through the family provision claim, do you think she's now made a will where she's left everything equally to her own kids and the stepkids? No. She's cut out she's cut out those kids and everything goes to her one biological child. But again, it's observation is blended families. It's a fertile area for this sort of dispute, and it's exactly the sort of area. Don't think it won't happen to you, because it will happen. And you really just do need to adopt some of the planning strategies that Susan was talking about.
Thanks, Carl. I'm planning on leaving all my wealth to my biological children only, but only because that's all I have. Well, she'll fix things after I'm gone. Those who don't know, my wife is rude and also works with me. Very beautiful and autistic children. So there's the procrastination element of people doing their estate planning. And I've seen it amongst my peers and observation about one who has a blended family. He was keen to do it, but really struggled with decision making around that because of some of the things you described, Carl. So, but there's a real risk to that procrastination. And I've seen two people die intestate who I'm pretty sure didn't think they were going to die. So, Susan, what are some of the issues that arise when someone dies without taking those steps in their estate planning?
So when people die without a will, that basically means that the Administration of Probate Act sets out who's entitled to receive the estate. And that goes down a list. So it'll be partner first, partner and children, or, there's children from a previous relationship, they'll get a cut as well. If there's no partners, go down to the children. There's provisions in there about people who have multiple partners. I could see that play out in person, but that would be an interesting one to be involved in. And then it goes down to sort of more remote next of kin after that. An interesting thing about that, though, is that it will be the person with the largest entitlement to the estate who is entitled to bring the application to get that as an administration, which means they get then appointed to manage the estate. That sometimes results in people who don't have the skills or the interest really in being appointed to manage the estate assets, but sometimes also that administrator role flowing to them taking control of self-managed super funds, family trusts, companies, and often it's somebody who doesn't have familiarity in all of that, and it really wouldn't have been the way that the person who's deceased, the deceased person, would have wanted. So we've seen so many cases where the wrong person is put in charge of these complex results, complex assets, and the results are not what anyone would have intended. So the planning is the key.
Let's bring you into the party. I think it's very helpful to get a sort of financial advisor's perspective on this. What's your experience when it comes to engaging with clients on estate planning and trying to advocate and persuade them to put forward into it and do it in a measured way that reduces the chance of conflict and follow through on wishes?
I've been trying to use some medical terms. I think I'm a GP's assistant. So it's down to us. So I think as it said there, I had a session last week where the financial advisor, but I actually think if you drop the financial part, our job is more around being an advisor and having conversations with our clients around, or just teasing out more than just that financial conversation around what they want to do, about their business, about their thinking, about their goals, how in the world, what that all looks like. So then, again, try and make some of these things grow. So narrow channels of our meetings, have the state meeting to talk to our clients about that. And typically what I sort of find is, don't have the stack, but would feel probably less than 50% of clients don't have their estate planning in order. Which would mean we're trying to use some stories of what's recently occurred or what's happened to try and sort of, maybe invigorate some change. But I think mainly it's there around, I think cost is probably one blocking point there for people. But what you sort of mentioned before, we kind of then go, well, if something was to happen in a situation, we've got insurance policies, super, family loan, some investment properties. It may be $5 million that's going to go to two kids. and we're talking about less than 1% cost to make sure is that's done properly. But bringing it back, I think, into a percentage terminology, then $4,000 or $5,000 might sound like a lot as an invoice. What it can actually fix is nothing at the end of the day. So sort of trying to change that mindset a little bit there. And so I want to kind of bring a couple of stories into that. And I guess the dramatic events usually for us is when someone actually then wants to make that change. It's been a result of a family member passing away, a close friend or brother. In a recent one for a client was the brother did pass away. He was the executor, and had to go to the brother's house out there because of something like that. And there's a room full of stacks in a payments, like it's no water, there's nothing. And probably it's, the client spent a year and a half filtering through what actual assets he has. Even that I had to fund costs during that time to actually get this from point A to Sunday, and that's it. And they found suit the last week after a year. But that sort of event for us then triggers those clients to go, I don't want to leave that type of situation to someone I care about. And then we sort of flow that into, we have a client portal that we use for our clients where we then allow them to click, sync, and just add all documents to that spot. So we try and use that from a perspective to go, it's a bit of hard work up front, but then from an estate planning is we can then underpin you got your plan done properly with a way that's going to actually hopefully get the outcome desired, but then also our business card or the login details to this portal, there is all of your asset balance sheet, things about that a banking sector is going to need, or try and simplify this process.
A little bit more homemade version of a friend of mine who's asked me to be his executor, gave me a roadmap, 3 pages, listing all his advisors, all his assets, and even his AOL email account password, which I thought was a little much less sophisticated than what Alex is describing. There are some very basic things you can do to make it easier on your estate. Have you announced it, Lisa? Carl, we because I work in the commercial space, and a lot of your work deals with business owners who must be thinking about succession. What are the sort of things that come up in conversation with your clients, or strategies that a business owner might have in mind that might lead to a smoother dealing with their estate on their death?
Yeah. So you say Carl.
So I heard you say Carl.
I was speaking a lot. So I'm seeing.
Comes up with a question.
Yes, I was prepared for it.
Knock it down.
I think, from a business owner perspective, this is probably where we try and use what I try and do is make business personal. Is again, when we speak to business owners, a lot of people's business is the main asset in their balance sheet. That's where they put a lot of their energy, a lot of their focus, and that's where the income is, and everything drives out of that. And then what we sort of, and then we talk about plan A. Plan A is a business going to do this, want to sell it, and that's my exit strategy, to potentially pay off mortgages, or that's the retirement nest egg. And then we then have that conversation about, okay, well, what happens if you pass away? Or say plan A is like this, plan B is, but what happens today if plan A doesn't work? And if your business asset isn't liquid, the business hasn't actually provisioned for how they're going to pay out your estate for your 50% share, that could be $2 to $3 or $5 million. That now isn't an asset that offsets the need for your estate, which should be leaving your spouse or kid for X amount of funds to pay off the mortgage and live a happy retirement. Told us you want to do. So that's how we then talk to, do you have those buy-sell agreements? Have you had those conversations with your fellow shareholders to go, hey, if we don't have this insurance, I'll sort of liquidity lever, my spouse or your spouse is going to come into the business and sit in my seat because they're going to be shareholder in business. Do we want? If you had those conversations, business owners going for, there's absolutely no way I want. Probably my spouse is the spouse wouldn't want to. The business partners would want their spouses to come. They're not aware of the business and what's going to happen. So you get to start and thinking to go, well, actually, if we put in place those insurance policies which provide that given you, for $3 or $4 million per shareholder might cost $10,000, $15,000, $20,000. Which again, from a percentage perspective, is nothing compared to the issues that you're then going if this wasn't in place. And they've talked about how do you fund it. So, is it higher salaries? Is this to pay for it to talk to again purpose? There's the key person cover that we talk to. We go, you're out, you're obviously providing importance to the business. So if you're not there, you might think that revenue might come down or your clients might leave. So there's a injections to your business. So again, thinking from a perspective of longevity, but also from the estate, is to go, you don't want to then have your kind of fire sale the shares. So it's making sure you talk to their accountant to get their evaluation. You also want to make sure that then they've spoken to a lawyer to have an agreement that is structured in a way that you need to have valuations done and into a box. Years, and then having those trigger events or insurance policies in place that actually then would work in the event that then happens.
And there's not many businesses that are ready for sale at short notice, typically, are they? So and then almost every one of these issues we've spoken about today is always compounded by grief. And so I think one thing that clients and advisors have always got in mind is this stuff's hard enough before you're dealing with the emotional load of this. So if you can actually have better preparation in place that lessens that load, seeing a spouse come in and try and take out now an extrusion business intangible isn't what they're looking for at that stage, is it, Alex?
No, exactly. And I think, again, when we sort of paint that picture of ideally they want their business to be growing, so that their share is going to grow, that buy-sell policy is going to grow. And so sometimes the business isn't actually big enough yet to fund where they want their life to be. They still need an additional trigger event or policy or outside of business. But ideally, they want to catch up with those clients, reevaluate the split. Eventually, business will be there. Suppose have the trigger. Everything's fine. Obviously, we say to the clients, probably going to be the worst dollar you've ever spent because you're never going to need it, hopefully. But if you do need it, we're here as your advisor to bring the right people in at the right time to make sure that your spouse is ordered in the right check that's sent to the right person.
It's all about planning. Have you any other thoughts about what role financial advisors might play in that process, or if we other books you had in mind?
In regards to exactly,
I suppose thinking about both the clients and their boundaries, and I suppose you have a longitudinal view of the person's financial future. So, not so much a crystal ball as binoculars, maybe.
Yeah, it's funny. I think that we experienced a lot of different events, and I ended up back. I sort of dealt with a, if we'd say a power of attorney that was sort of, dealing with the mother who was at a aged care facility blind, and, we're trying to clean up. The dad passed away, sort of trying to clean up this estate. And then we started going through that process, and sitting there with the sister, he was sort of talking about how the kids wanted to get, the mum wanted to pay the kids $5,000 or $10,000 each to go overseas, and the sister was going, don't know about that. A joint powers of 10. And he also calls up saying, is it okay if I'm being handed myself in the bank account to administer this stuff? And I'm like, should I tell my sister? No, absolutely, you should. Which she didn't. And now not their advisor because, isn't what you should be doing. I think there's a point where you go, I've got $5 trillion of assets coming through the pipe. You try our best to have better conversations with clients. But at the end of the day, people just don't want to take advice themselves. But our job is to, again, understand those dynamics, the blended family, the sisters, whatever that might be. But really is to then hopefully, give it to it on a plate to people like Susan to then draft it up properly. And then they can sort of, sleep easy going, piss gun. So we're not lawyers, but we understand, dangerously what might happen if something's happened. So we're trying to get that trigger event to get some trigger.
Sometimes our job is to bring the warm economics, isn't it?
Correct.
Only got a few minutes left. I'm told that there's coffee available for you after this. There's a question there there's a question which is framed, which might just blow things up. The recent federal budget and the impact force. which was that's all taken. We've got a question there.
So a few different angles. Obviously, the budget came recent, quite significant. Alex, hearing you talk about triggers, and I'd imagine that's something that people are going, oh, geez, I better go and see my advisor. I better go and do that. But I assume there's probably also some impact on our estate planning that's coming out of the budget. I assume that is the question you were going to ask as well.
But don't be by the floor.
Well, I guess from a financial planning perspective, a lot of our job being in this last little phase is to just basically tell people that it's proposed, it's not legislated. Making dramatic changes to your assets, selling things, moving properties, whatever that might be, is actually potentially going to cost you a lot of money for something that you didn't need to do. Again, our job is to educate and explain, because I think a lot of depending on what newspaper you read, especially millennials, like, oh, I'm going to pay 47% tax, like, not even earning enough to go. So I think that's, again, what they read and how they take it is very different to reality. So again, our job is to sort of navigate changes to legislation, explain to people, if they're even worried about, not even close to the 3 million curve hurdles, let alone yourself. So again, I think from that perspective, it's just sort of saying that, so far, yes, there's going to be potential changes. It's only from a point in time going forward, so everything behind is the same. And they go, anyway, that's not as bad as I thought. Yeah, it's not. So I think people just automatically go worst case scenario. And there's definitely going to be changes that are going to make it different. But I'm thinking guidance, again, he's got a good opportunity to, if you know a quality accountant, just to actually go to your accountant to discuss about structures and adjustments, because again, we're not lodging the tax returns or that tax advisor, but there's a big element of tax here to then, again, understand potentially how it might impact the client, bringing the right person at the right time to action then us.
Found any other comments on the budget?
Just a quick comment. A lot of our clients, our estate planning clients, are getting very spooked about the much talked about 30% tax on all discretionary trusts, including testamentary trusts. Our advice to them at the moment, like Alex said, is just wait and see what comes out in the legislation. Nothing is set in stone yet. There has been a lot of outcry and lobbying by different legal groups. So there's potential that may be rolled back. We're not sure. And there are a lot of other benefits to using trusts. So even if the tax is put into place, it doesn't mean that you need to go and change your will. The trust has a lot of other benefits as well when it comes to asset protection, protecting vulnerable people, protecting people when they get divorced or bankrupt. So there are other reasons to have trusts in your will besides trying to minimise the tax payable, but even that there may still be tax benefits as well. We just don't know yet.
I like that perspective, Susan. I think that's very important. It gets very focused on this question.
I've had a question online. What is the difference between a fixed and discretionary trust?
What is the question between a fixed and a discretionary trust? But I'm still let you know that it's 9:01. So a punchy answer for this.
Can we jump back really quickly? It's in the name. So a fixed trust, the beneficiaries have a fixed entitlement. A discretionary trust, it's at the discretion of the trustee. So the trustee decides who receives income and capital distributions.
And if only because in time, I think we might thank our panellists, Susan, Alex and Carl. They'll be available as the coffee cart continues after this. If you have got some more questions, you haven't got it, Will? Yeah.